Okay, everyone. My name is Gabriel Sepulveda Sanchez, and I am the founder of Sepulveda Sanchez Accident Lawyers. We have a we have offices in California. Our main headquarters is in Los Angeles, and we also have a physical office and presence in Stockton, California, where I'm from. I've been an attorney specializing in personal injury since 2012 and have an extensive amount of experience with wrongful death cases, trucking accidents, auto accidents. We have a great team here. We've got about four attorneys plus another 27 or so staff members. So we're growing, and it's been an awesome experience since starting out back in 2012 as a lawyer and starting the business in 2015. The purpose of this live today is to really understand what a personal injury case is. And usually, most people go their whole lives without getting in a serious accident, which is a good thing. But there are some people out there that get involved with serious accidents and have been involved with car accidents, trucking accidents, a bad slip and fall, someone else's negligence has caused their injuries, or someone else's negligence has changed their life and their quality of life. And usually those things happen once or twice in someone's life, but they can happen. And my job today is to educate you on if in the situation that does happen, if you know someone that's been injured, kind of guiding them through that process and just giving more educational value through today's live. So the first thing I want to talk about is what is a personal injury case? And personal injury is it could be those are very broad terms. So, injuries happen at the workplace, but for purposes of what we do at our law firm and for what I specialize in is I typically take cases outside the workplace. So a personal injury case it's pretty simple as far as like the concepts go. But number one is it's really just negligence and damages. And negligence is basically when it sounds just the way it sounds is just the way it really is in the legal world. If someone's careless, negligence is another way of saying careless. If someone's careless in the way they go about their lives and the way they drive their car, in their duty, and there's whatever, if you have a special relationship with this person, whether it's a lawyer, doctor, and their carelessness causes you harm, that's negligence. Okay. So basically, negligence is another way of saying carelessness. And then damages is the second component of a personal injury cases. If there's negligence or carelessness, that's one thing, but you got to have damages. So sometimes you have carelessness or negligence, but there's no injury or harm to you, and there's nothing really we can do to help you out. But once you have carelessness and damages is harm to you, economic harm or physical harm, that's when you have a case, and that's when you have a negligence personal injury case for purposes of this discussion. So kind of exploring what negligence or carelessness is in detail. Really in law school and basically not just in law school, but what the law is that negligence or carelessness in the personal injury field is basically there's a duty that was owed to you, there's a breach of that duty, and there was actually causation. So kind of break that down from theory to real life is that just regular people in our day-to-day life, we all have a duty to each other. We have a duty to act reasonably to one another, and that's what they call as a reasonable person duty. So if I'm walking down the street and I have a duty to be reasonable to other people, to conduct myself in respect for one another. And that's a duty that everyone has here in the United States. You have a duty to be a reasonable person to conduct themselves in a reasonable manner. So an example of being careless is if I'm walking around and I'm drunk and I'm just stumbling around and I knock someone over. Well, there you go. I breached my duty of care and reasonableness to another person in my neighborhood. So you have a duty that was owed, a duty to be reasonable to other people, and then you have a breach of that duty, and the breach is being careless or being drunk and knocking someone over. Okay, so you have the two components of negligence right there. You have a duty that was violated, a duty that was owed, it was a breach of that duty, and the second component is causation. And the causation is that because of my carelessness and my breach of my duty to be reasonable to other people, and this caused this person to fall and break the arm. Okay, so now you have causation, the element to that. So, for example, you wouldn't have causation if if someone's walking around drunk and they're careless, and then this guy just trips over a rock or something. And that's not the case. Even though I was careless and I breached my duty of care to other people, arguably, but this person, I didn't cause the actual fall. It was some other incident or some other person or thing that caused the incident. So you have to have all three components in a negligence case. So just kind of to break it down more. There's all sorts of duties. So that's one regular duty. When you're driving a vehicle, you have a duty to follow the traffic laws. If you're speeding, running a red light, you're breaching your duty of care. It can get even more nuanced. So, there are special duties of care. So if you're a doctor, you don't have a reasonable person duty. Now you have a duty of a higher standard of a medical professional. So there's a higher standard of care for that, for those types of people. If you're holding someone else's money in trust, it's not just a regular person duty. You have a special higher care, you need special licensing, credentials to do those types of things. So I don't want to get too in depth with that, but that's what a duty is in the personal injury field. There's different types of duties, but for the most part, it's all about being how a reasonable person would conduct themselves amongst others. The next part about a negligence case. So you have negligence. One of the other parts about negligence is liability. Okay, so I want to discuss liability for a little bit. Liability basically means that there was some sort of it's really the breaching of that duty. Exactly. So when someone says someone's liable, that means that, like, hey, for instance, in a car accident case, you have a duty to obey traffic laws, and you breach that duty by running a red light, and it caused this person's caused you to T-bone another person's vehicle, and they got hurt. Well, that person's liable in that case. Okay. Now, there's some situations that what's called comparative liability, and people often call us because they're concerned because they might have been at fault too. We've had cases where the person had alcohol in their system. They were obeying the traffic laws. They weren't swerving. They weren't, driving their vehicle in an observant way that was reckless, but someone ran a red light while they happen to have alcohol in their system. Or maybe someone ran a red light and then they have their seatbelt on, which caused further injury to them. There's an argument insurance companies like to make, which is called comparative negligence. And some people get worried, like, well, yeah, that guy hurt me, but I was also at fault, or I had alcohol in my system, or something like that. And the good thing about California is we have this doctrine called comparative negligence, which means that even though you're in negligence, it doesn't really bar your claim to damages still. So even though you might have not had your seatbelt on, you might have been negligent yourself to an extent, this other person's negligence outweighed yours. So you can still recover damages for your injuries, but it's going to be reduced in accordance to how much percentage of at fault you are. So other states out there have like bars to comparative negligence. So if you're found any percentage at fault, even though you were hurt by someone else that was also at fault, they'll bar your claim. But not in California. It's a good state for people that have been injured and consumers out there that are wanting to exercise their right to compensation. So comparative fault means that I have a little fault on me, but you can still sue the other person for the majority of your injuries. So that's one of the good privileges we have in our state. Damages. So this is a big part of what we do as personal injury lawyers. Our job is to get you the most compensation for your damages that you've sustained. Without damages, we really can't do anything. Some people have, they've been injured in an accident. There's the liability, the negligence is there, liability is there, but they're not hurt. There's no damages there. And at least they don't think they're hurt at the time. You got to have damages for us to be able to do anything. So just because someone's negligent, you have to have something that's evidence that there's actually been some damage done. Property damage is one form of that. Medical expenses, medical documentation showing that you're hurt. Those are proof of the damages. And without damages, without some concrete evidence of damages, we really can't do anything to help you. So it's very important to really understand that. two specific types of damages. There's economic damages, which is past lost earnings, future lost earnings. A lot of people are severely injured where they can't work for the rest of their lives. So you have to show a life care plan, which documents their medical expenses, what they're going to be for the rest of their lives. But the primary economic damages, there's the lost wages, past and future lost wages, which you can recover if you can show proof of that, and also past and future medical expenses. So those are the main economic damages that you can recover. The second component is non-economic damages, and what people the myth is it's called pain and suffering, right? People always talk about pain and suffering money, emotional distress money, but people don't realize in California, non-economic damages isn't just pain, isn't just suffering, isn't just emotional distress. It's a whole list of 10 categories. I believe it's 10 or even more of each specific category you can recover damages for. Non-economic damages. So anxiety, past and future anxiety, past and future pain, disfigurement, emotional distress, mental suffering, loss of enjoyment of life is a big one. There's grief. So all these categories, it's not just pain and suffering. What makes the jury system really empowering for injured victims is that they can advocate for each of those categories. As long as you have evidence that you have lost your quality of life, and it's going to continue to, your life quality is not going to be good for the rest of your life. You can prove that. A jury can put dollar amounts on each of those categories. So that's where the majority of the value of a case is really your the non-economic damages part of it. And as lawyers, that's what we're supposed to do. So we're really supposed to advocate for those non-economic damages part. And the thing about insurance companies, they get scared of jury trials because when you hear these big verdicts, it's because the juries have heard a story about those non-economic damages and it's how this person's life is no longer what it used to be. And that's where the real value comes in your case. So very important to understand that. And that's one of the cool things about the personal injury field and what we can do is really get in the courtroom and advocate for that. You tell a good story about it. Insurance limits, another big topic people talk about or people want to know about. The unfortunate thing and I guess it's just life, but insurance limits we're really kind of like what's the boundary in this case? You can have someone could have ran a red light and just, something bad could have happened to another person. They could have lost their life. They could have lost their, can no longer walk. It's sad stuff. We see it. Life's changed forever. But that person that hit you has the minimum insurance policy, then they're not going to get more than that. And that's there's exceptions to that. There could be uninsured motorists there, or it could be, another defendant, or could be, there's exceptions to it, but for the most part, you're really going to be limited in your recovery by what kind of insurance is at play. So in California, we used to have a $15,000, $15,000 per person, 30 per incident limit. Thankfully, they raised that up to 30. So now we're getting better settlements for our clients because the insurance limits are raised. But back before the new law passed, you had a lot of people driving with minimal insurance or worse, no insurance at all. So when you're evaluating what kind of case you have, or if you have a case, what kind of insurance behind it is a big part of that question. And part of what we do at our firm is we want to make sure when we're managing your treatment or we're giving you a proper evaluation of your case, we want to know what the insurance limits are, so we can actually kind of give you good advice and tell you what can be expected. Uninsured motorist coverage is super big. I've seen a lot of cases where I could have got this person $1 million plus for their injuries, but they got hit by someone with minimal insurance, or even maybe not even minimal, maybe $100,000 policy. You got hit by someone with $100,000 policy, but you had no uninsured motorist coverage. It's hard to do anything above and beyond that, because if you had uninsured motorist coverage for $1 million, and it is a lot of money, but really paying those premiums, it's not as expensive as people think. And you probably should do that. If you're paying another $30 a month or $50 a month, it's better to have that protection, because I've seen cases where they've have their lives changed by someone else's negligence, but they have no uninsured motorist coverage. The guy that hit them has minimal insurance. So that is very common. And that's why it's very important to get uninsured motorist coverage and check what your limits are. So this is a general primer on what we do with insurance limits. When you're hit by a company or a commercial vehicle, there's commercial policies involved. Uber incidences, Lyft incidences, they have commercial policies. So if you're injured by an Uber driver or Uber driver's negligence caused your injury, or if you're a passenger in an Uber, typically those could be good cases because they're big insurance policies, and we have a good track record of holding Uber accountable. And that's part of the reason why they're trying to pass this new legislation limiting our fees, because we caused them so much loss in their profits of advocating for people who have been injured. So that's one of those things you're seeing with the tort reform and what Uber's trying to do as far as limiting access to courtrooms for personal injury victims. And that's why, because we sue them, and we sue them for a lot of money. So next thing I want to talk about is the medical treatment documentation part that goes into damages. It really goes into the damages part because the insurance companies, they have to have something. They have to justify giving you compensation. You can't just tell them I'm hurt. They have to see evidence of that. And really, the two biggest things they're going to look at is what was the medical documentation here? Like, what does the medical report say? And what are the medical bills? So those are things you want. If you're injured, if you get hit in an accident, you get rear-ended, or you're in a regular fender bender, and you have no medical documentation whatsoever, and worse off, say you wait months before you get treatment, and people do that, then the insurance company is not going to compensate you because they need something actually tangible so they can justify giving you compensation. So it's very important, even if you're rear-ended and you feel like you're okay, we always advise it's good to go to urgent care. If there's telemedicine, there's things that are convenient now. Get something documented that you're reporting pain or you're concerned about pain, because that itself helps protect your case, and at least gives the insurance companies something that there's some documentation evidence that you're actually hurt. So very important to document and get treatment. Some people just don't feel the injury right away. I've been rear-ended and been in a couple accidents, and sometimes you just don't feel it. And you just feel it for a few days later. Or sometimes like life gets in the way and you just don't want to go treat. And I get that. I'm a busy guy. Like I'm taking care of other people, so I barely take care of myself sometimes. So, but it's very important. If you've been in an accident, if you know someone, like make sure they're getting that documentation very soon after that incident. Also want to talk about demands and settlement negotiations. So basically, once you have the case is clear, you got negligence, you got damages, the liabilities there, medical documentation and medical bills for injuries. What a personal injury firm should do is, once you're done treating, we'll send a demand letter to the insurance company asking for the policy limits that are available. And we have a special crafted demand letters that's really make sure that they're not hiding any other insurance policies that we can't get a hold of for your case. So once we do that, we'll send the demand letter out. By law, the insurance companies need at least 30 days to evaluate that demand. And then typically what they'll do is they'll start a settlement negotiation process with you, where they'll either give you the policy limits for what your case is worth, or maybe they won't give you the policy. Maybe you didn't treat that much, or you didn't have a lot of injuries in your medical file. They'll give you an offer, and it's our decision to negotiate with them and settle it, or go into the litigation phase. So the litigation phase is when there's no negotiations with the insurance adjuster. They failed. They're too far apart. We feel your case is worth $1 million. They're saying your case is worth $200,000. That's where we're like, okay, we're just far apart. There's no hope in us talking. We have to go to litigation. And that's when we file a lawsuit against their insured. And then typically what happens is that we move that case towards trial. We take depositions and really work up we call it discovery. It's really just building up your case towards trial and gathering the evidence, exchanging information. The good thing about litigation is that typically sometimes a new adjuster is assigned to it, a litigation adjuster, or the attorney, the insurance defense lawyer, will counsel the insurance adjuster on, hey, this is why he should settle. Like there's a risk that they can go to trial and get an excessive verdict, and your insured could be can be found liable for the excess judgment. So that's what the litigation process is. It's really our way of getting more compensation for you and really having that leverage of a jury trial. one thing to kind of understand too is that the insurance companies have this like inherent conflict of interest. When the insurance companies, we all have auto insurance, hopefully, and we have health insurance, but the insurance adjusters, their job is to make sure that they're protecting you, a policyholder, that they're settling your claim and making sure you're not going to risk your own assets over some lawsuit. So, but the problem is that they also want to make sure they keep the profit. They're incentivized to make their companies more profitable. And the insurance defense lawyer, he's really supposed to be representing the policyholder, but really he's making sure the insurance company is happy with, because they want to save money. So there's an inherent conflict of interest with insurance defense lawyers. They're supposed to represent the policyholder, but they're really representing the insurance company. And that's something to kind of be aware of in those situations, that even though you're a policyholder, you really can't trust your own insurance company at all. Because they have a different interest in you. Next thing I want to talk about is contingency fees. So when you see all these advertisings about no win, no fee, no win, or we don't if you don't, we don't recover, you don't recover. What that is basically a contingency fee. And what contingency fee agreements are good, because typically most people out in the world can't afford to pay an attorney their hourly rate, what they're worth, or what their experience and time is worth. So what we do is doing cases on the contingency fee allows us to represent people without a lot of resources, without a high net worth. And what we do is we represent these people with the promise that, hey, we're going to advocate your case. We're going to expend the money we need to get the best result for you. And we're not going to bill you at all. But when the case settles, we're going to have a percentage of that settlement. And what that really helps is that people that wouldn't have access to lawyers, typically they're able to, because we're able to take on those cases on a contingency fee. So, that's one of the good things about personal injury lawyers. Good personal injury lawyers should not bill you out of pocket. They should take it. And if it's a case that potentially they can win for you, they're going to take it. They're going to take that risk and take that case on with the belief that they can get you compensation. The more money they can get you, the more it benefits them also. So that's why that's what contingency fee agreements are, and that's why you see these advertisings out there saying that we don't get paid until you win. So that's what it is in essence. Common mistakes people make for their cases is, number one, talking to the insurance adjuster like right away after an incident. The insurance company is not your friend. They're not there to help you out. They're here to save their money. So when you call them after an incident and you tell them that I was in an accident, I'm not hurt, I have no pain anywhere, but I want my car fixed. Well, they're recording all that, and they're recording everything you say. So then, for instance, you get next 2 days, you're hurt, and then you hire a lawyer. Well, the insurance company is gonna hold you to that. Like, well, you just told me you weren't hurt the other day. So they're looking for ways to devalue your claim. So you have to be really careful about what you say to them. My usual advice to clients is first of all, just let us handle it. Usually a good law firm will handle the property damage for you, handle the injury claim. However, if you're compelled to talk to your insurance company, deal with the property damage only, and you don't have to talk about the injuries. Say, on the advice of my attorney, my attorneys will handle my injury claim, and I'll just handle the property damage. And then say, if you're hurt, yes, I am hurt. That's the extent of it. Then my attorney can talk about the details. So, because they're going to hold you to that, and they're going to looking for ways. If you say you got an accident the first day, you're only feeling pain in your back, but then a week later you have pain in your shoulder, and you didn't tell that to the adjuster, they're going to wonder why you complain about that. So it's just BS games they like to play with consumers. But that's the number one mistake I see. And also failing to call the police. You should always call the police when you're involved in an accident. If they say, well, they'll answer they won't come out unless you report an injury. And some people are just tell them, yeah, we're banged up a little bit, so have them. It's good to have a police report, because they'll actually collect the insurance information for everyone, and they'll get it documented. And the police will typically put a conclusion on who's at fault based on the statements they have. So it's good to call the police when you're involved in an incident. and get treatment right away. Even if you don't feel that hurt, just go to telehealth, go to urgent care, and get some medical documentation because they'll help your case out in the end. So that's it for just the general personal injury topics. Again, my name is Gabriel Sepulveda Sanchez. I've been doing this since I've had the firm since 2015. Been a lawyer since 2012. Yeah. So I've been doing this for a while now. I've seen a lot of different things and really have a passion for advocating for people. And it's a really cool experience when someone came to you and they don't know what to do and the case looks bad, but we're able to help them out and change their lives with an amazing result. That's what keeps us going. And my whole team's great. We all love what we do here. So I'll open it up for question and answer. If anyone has any questions for me, we'll go ahead and talk, and I can see if I can help anyone out here. Let's see. Let's see. Is there a chat here? Chat. Oh, I was muted, huh? That sucks. Am I muted? Oh, no, I'm okay. Okay, so what makes one case worth more than another? So let me just make sure I'm reading this right. What makes one case worth more than another? So am I still muted on my personal one? Can you guys hear me? Let me see. Can you hear me? Anyone on my personal page? I think I'm good. What makes one case worth more than another? The simple way to say it is that the more injuries there are and the more insurance there is, the more your case is going to be worth. So if you got a case, same fact, someone got rear-ended, but one person has a broken arm and one person has whiplash. And assuming there's more insurance on the case with the broken arm, that case is going to be worth more. But there's not a lot of insurance on the broken bone case. Say you got rear-ended, and you have a broken bone, but the guy had no insurance. But the other case, someone had whiplash, and there's $100,000 policy. Well, it's going to be worth more because the insurance is there. So it's really about how badly you're hurt and whether there's insurance. What are the insurance limits there? So that's going to make your case more worth than the other. That's going to make your case a higher value case if there's higher insurance limits there. So another question is, how do you actually prove negligence if it's my word against the other driver? So how do you actually prove negligence if it's my word against the other driver? So that's a good question. So basically, sometimes there's cases where one person says I had a green, the other person says no, I had a green. Well, those are kind of word for word cases, and really, what's going to come down to is you're going to really have to scrutinize the collision report, or really just kind of see what story makes sense the most, and it's a judgment call. So, those cases where you have a word for word case, it really comes into judgment. You kind of look into this witness, what kind of person they are, if they have a history of if they're deadbeats. If my guy's saying he had a green light, and the other defendant saying he had a green light, then I look into this defendant, he's got a criminal record. I kind of make that judgment call. That's a very good question, and that can make the case complicated. And also just using common sense. If it just made, they could, looking at the incident scene, you can kind of tell what story makes sense also. But it helps to have a witness. So if my guy says it's a green light, your guy says the defendant says it's green, but I have an independent witness that says no, your client had a green light. that helps. When you just have two people one-on-one, it can make things a little tricky. That's when you have to use a judgment call, and really it can go deep. You can get there's accident reconstructionists. You can see crash data, the black box in the vehicle. There's different things you can do, but that could change things with a word for word accident. What makes one case worth more than another? We talked about that. How is fault determined if there are no witnesses? That's how is fault determined if there were no witnesses? Well, basically, if you have no witnesses, it's just you and someone else that was hurt, then it's really like I just said, it's really just kind of seeing who's more credible as a witness and really kind of looking at the scene and how it played out and whether that makes sense or not. So it does make things a little more tricky when there are no witnesses. You're going to have to really think about what kind of client you have, what story makes sense. Looking at the property damage too, like you can tell a lot on how the mechanics of the accident happened. If there are no witnesses, you kind of figure it out. So that's one way to do that. Okay. Another question. How do I know if a settlement offer is fair? Well, it really just depends. It's really like if you're got life-changing injuries, right? And the other person like had a minimal, say you have like broken legs and the guy had a $100,000 insurance policy. Well, it's like, it's really not fair because your injuries are worth more than 100,000, but you have to look at it like, what's the what are the cards that are dealt to me in this situation? If you got a case where you got something severe, that something really bad happened, but there's minimal, let's say there's $100,000 insurance. Well, like that's the most we're going to be able to get, assuming there's no other insurance involved. So is it fair? Fair? No, it's not fair. But in light of the situation, you should be getting at least your medical bills, or a lot of your medical bills paid for. And I think the majority, just getting the most from that settlement, that getting the most out of that, it's insurance limit is what matters the most. So let me see here. What are the questions we have? Let me see my personal page. What's up, Matt? Can you hear me? Okay. All right. Good to see you, Matt. What else I got? Send me some Crocs in cases. I know you know a lot of people. Let me see here. Will I have to go to court or testify if my case goes into litigation? So let me see this question. Let me read that again. Will I have to go to court or testify if my case goes into litigation? So usually in a litigation, when you're in the litigation process, you will have to do a deposition. And what a deposition is that it's just the insurance company's way of asking you, they want to hear your side of the story and get your personal observations, what you saw, what you heard, what you said at the scene of the incident, what happened before and after. They want to hear about your injuries. So that, yes, you do have to testify, and it's not necessarily in a courtroom. They'll do a deposition in a conference room with a court reporter, and they'll take your deposition testimony. So yes, typically in a litigation case, you're going to have to testify, not necessarily in court or in a trial, but at least in a conference room setting during your deposition. And the attorneys will prepare you well for that. So most of the time, I would say 90% of the time, the case is settled. So you don't need to go in front of a jury and in front of the courthouse to actually testify. But when you're in the litigation process, yes, there's most likely going to be a deposition that takes place. How do you know if my set off is fair? How is the emotional distress determined? So emotional distress, you don't necessarily need medical evidence to show that you have emotional distress. I think what I've seen in my cases is that if something bad happened, and I've seen horrible things happen, and unfortunately in this line of business, um, say you have a traumatic brain injury now, say you can't walk right anymore. Um, well, it's obvious to the jury when they hear you testify, and there or someone else is testifying about you being depressed, you being sad because you're not able to do things you used to be able to do before the incident. The jury, that's evidence itself of emotional distress. Someone else testifying about how your behavior and how bad things have gone after the incident, that's emotional. That is can be considered emotional distress damages. So obviously, if you have medical documentation showing that you're seeing counseling, or you're just going, you have depression, you're getting anti-anxiety or depression drugs, whatever it is, psychiatric medication, that could be evidence of emotional distress. But also just testimony, someone testifying that, I'm seeing, before the incident, he was a happy guy. Afterwards, he doesn't get out anymore, and he stays in the house, and he's depressed, and he's reclusive now. That is also a way of proving emotional distress damages too. So there's different ways to prove that. It can be through medical documentation, expert witnesses, or just people testifying that you're not the same. That it's really the jury. The jury can evaluate that and figure out how bad, what kind of emotional distress damages you have. Okay. Okay. What other questions we have? Let's see. How do you actually prove negligence if it's my word against the other drivers? Just saw that. What happens if I miss the statute of limitations? Well, if you miss the statute of limitations, you're not going to be able to pursue your case anymore. So typically in California, for regular accidents, typically it's a 2-year statute of limitations. So you're going to have like 2 years to file a lawsuit from the day of the incident. There are certain exceptions to that. For example, if you're a minor and something happens to you and you're a minor, well, you can wait years until you're an adult till you're 18 to go ahead and pursue that claim. But also there's shorter shorter statute of limitations too. I don't want to get into all of them, but if you're, say, a corporate government was negligent and caused injury to you, you have 6 months to make a written claim, and then you got from there. If they deny the claim, you got a year. I'm sorry. I don't want to get too into detail on that, but if you're injured by a government entity, your statute of limitations is not 2 years. You have a significantly lower amount of time to file a lawsuit. So you have to make sure you file that. If you're injured by a government, say a police officer fails protocol, runs a red light, and didn't do what it was supposed to do, and hurts, causes bodily harm to you. Well, you got to make a written claim form with that government agency within 6 months, and then from there, depending on whether they accept or deny that claim, you have to file a lawsuit. Once they deny that claim immediately. So there are shorter statutes of limitations. There are longer ones, but for the most part, it's 2 years. But there are exceptions to that. Usually, the courts are very unforgiving if you blow that deadline, but there are some exceptions. Say you're in prison and you say you had an accident and you're in prison or something, you're incapacitated and you can't do anything. Well, there's some exceptions you can get by for blowing that statute. But for the most part, you got 2 years to make sure you pursue your rights, to file a lawsuit. Why do some cases take years? What causes delays? So some cases, there's a couple of reasons why cases can take a long time. I think what's important is that assuming you have a good firm that's proactive and moves the case forward and with just does what they can in their control, the case shouldn't take that long. There's some firms out there that like just sit on a case, say they know that the insurance adjuster is just too far apart in the value of the case, and they'll sit on it for months before they do anything. There's a lot of things that lawyers can do to minimize the delay in advancing a case forward. But in those situations where there's a lot of injuries and there's a lot of insurance at play, sometimes those cases could take years because you're not just talking about $1 million. We're talking about 20 million. We're talking about $50 million. The insurance companies, government agencies, they're not going to just hand that to you. They're going to make you fight for that for a long time. A lot of times they'll delay cases. They'll ask for continuances in the trial. There's a lot of stuff they can do to kind of delay it. So when you're talking about big numbers and big injuries, sometimes it's more complicated. There's way more witnesses. There's way more expert witnesses, more witnesses, more damages. There's a lot of people that we have to take depositions of. That's sometimes it can take years to settle a case, but for the most part, it doesn't. A lot of times courts are backed up too. You can file a lawsuit in certain counties today, and you won't get a trial date for another 2 years. So some counties are different. You can typically get a trial date within a year, but sometimes it takes a lot longer. So it's important to, it's one of those things. It just depends. Like if it's sometimes you have serious injuries and big insurance, and they settle with you quick. But the ones that take a long time, they're very complicated cases, and we're talking big dollars on big dollars on the line. So those are the ones I've seen. The more complex cases, government entity cases where there's like scientific experts, dangerous road cases where you have to hire a bunch of experts to figure out even if you have a good case. Those could take a very long time. The more complicated it is. How do I know what the insurance policy limits are? So it's easy to find out what your insurance policy limits are. You can, if you want to know, some people don't know what their own insurance limits are. You just got to look at your declaration page, ask your insurance company for your declaration page, and they'll show you what your limits are. But for the other person, they're not required by law to disclose what their limits are to you. Personal injury firms have ways, and there's tools that we use and research tools where we can find to an accurate extent what the insurance limits are. And a lot of times, if you request it with the insurance company, our firm will request the insurance adjuster to release the limits. A lot of times they'll tell you too. So they just have to have the insured's permission to give you those limits. So sometimes they voluntarily let you know what their limits are. And sometimes you have to use a research tool that most firms have to figure out what those insurance limits are. Okay, that's a good question. Do I get taxed on my personal injury settlement? In California, you do not. So for personal injury cases, your personal injury settlements are not, you don't have to pay federal or California income tax on them. That's the best part about the law and the industry we work in, is that we have to pay taxes on our fees, obviously, but people that have been hurt, they don't have to declare that. They don't have to put that down. They don't have to claim that amount. That's their money. Now, for other types of law, for example, employment cases where part of the settlement amount was the lost earnings, or not lost earnings, but their ability to not find work for so long, or the back pay. Employment cases are typically, you can get damages through back pay. So a lot of those times, those are taxable, or sometimes the settlement, they'll take the tax out of it. But that's employment law. That's not personal injury. But in our cases, no, you do not have to pay federal or California income tax on your personal injury settlement. Can negotiating too aggressively hurt my case? That's a good question. So I would not recommend you aggressive. I don't recommend anyone to attempt to negotiate a settlement on their own, because as lawyers, we know every single category of damages we can get for you. We also know how to maximize that settlement amount. And we're our expert negotiators. That's what we do. So I would not recommend anyone to do that on their own, because you could negotiate against yourself. Sometimes these adjusters would have given you more money, but you didn't. You thought you were doing a good job, and and then they give you, oh yeah, I'll give you that, because in their head they knew what they could have settled for. But as a lawyer, I think it's a balance. I think for me, my style of negotiation was to really come to an agreement, kind of reason with each other a little bit. Like, I don't believe in really attacking an insurance adjuster and making them defensible, because that just kind of solidifies their position. However, there is a time for that. Sometimes that they're just really not respecting the injury. They're not respecting the case. Then you have to be more tough. And then sometimes it's good to have some pressure and to really it's good to scare them sometimes too. So it really just depends on the situation. If they're not being fair at all, then sometimes you gotta be more aggressive with them. So, question: do police reports determine fault? Do police reports determine fault, or can they be wrong? So, police reports. This is the common myth too. If a police report puts you at fault, it does not mean anything. Okay, like all that means is that the cop took a statement from the other driver, took a statement from you, whoever, a witness, and he came to his own conclusion on who's at fault. It doesn't mean anything. If police reports are hearsay, so in court, they're not admissible to prove who's at fault or not. That being said, insurance adjusters do like to use those to kind of evaluate their own decision on liability too. So does it have value in a negotiation? Yes, but it doesn't mean in the litigation process. It's not admissible for fault at all. It just shows you what the witness statements were and what the police thought based on his conclusion, based on his observations of who's at fault. So they are not admissible. One of the things I'm very proud of at our firm is that we've had numerous cases where a police report put our client at fault. They thought they had no hope, and we got them record-breaking settlements and verdicts in California with a police report that was bad, put them at fault. Even if a police report this is an injury case that comes to my office and the police report puts them at fault, I still like to look at it, and because I want to know based on what I'm seeing is that's true or not. And sometimes police get it wrong. They don't get the accurate statement down. They're not experts. They're not personal injury lawyers. They don't know the law like we do. So police reports are not that valuable. They're not as valuable as people think they are. So what exactly is in a demand package, and how do you decide how much to ask for? So in a demand package, the basics are you're going to need the medical records in there that show or document your injuries. You're going to need the medical bills, any evidence of lost earnings. Whatever the demand package should have everything in there that an insurance company needs to evaluate how much they're going to offer you. Also, not just the documents attached to the demand, but the body of the demand itself. We'll list out the case law that's applicable to this case, why they need to pay us, what's at risk for the insurance company and their insured if they don't, certain laws that make our demand compliant. Those are the primary elements of a demand, and more importantly, a time limit. You got to have a time limit on it, and the amount that we put on our demand, it really has to do with what the insurance limits are and what our client's injuries are. So if we have the amount of medical expenses down and the future medical expenses, we list that. You lost earnings, but the big one is just the injury portion of it. And like I explained earlier, the non-economic damages part, having the emotional distress, the physical pain, the disfigurement, whatever it is, really listing that out and telling that story in the demand, along with documenting everything with real records and bills. That's what's typically in our demand to the insurance company. All right, I think that is about it for me. So, I think we're going to wrap it up. For those that are on, thanks for joining, and we'll see you next time. Thanks.